Counselor, good morning to you. Counselor Tito, could you give me the correct pronunciation of your last name, please? For Darren Green. Counselor for Green.
Good morning, Your Honor.
Yeah, give me the correct pronunciation of your last name, Counselor.
Shaito, I won't be mad if you say Cheeto too.
Shaito, I want to get it right. Darren Green, I just let him in. D-A-R-I-E-N. All right, let's see what this is. Is that Darren Frederick or is that Darren Jalen Green?
Yes, Your Honor.
City of Detroit versus Darren Jalen Green. Case numbers SP 1300399, counts 1 and counts 2, SP 1461159. Appearance for the record, please.
Ali Shaito, P77614, on behalf of Mr. Green, who is present via Zoom. Mr. Green, can you please state your name for the record?
Darian Green.
Darian, sorry.
Your Honor,
Today is. Go ahead.
I don't see any of the police officers present. Officer Nicholas Hunt, Robert Holt, or Alexander Kucheravi. So we're going to be moving to dismiss this case, dismiss these matters, Your Honor.
I get that, but it's a little premature, Counselor. I'm going to give them a half-hour grace period to check in. We do have one. Kucheravi is here, so we'll give Officer Floyd a grace period, and we will see where it goes. Holt and Hunt on the other matters. I don't see them yet, but the one officer is here. All right, so let's pass the matter until 9, at least at 9:30. If they don't show up by 9:30, then we'll recall the case, and then we will get an opportunity for you to speak with Madam Schneider, the Corporation Counsel.
Your Honor, if there was an officer present, Officer Alexander, I think I did speak with Mr. Green, and there was a plea recommendation available, which is to plead guilty to the disorderly conduct under a delayed sentence, 3 months, and have the other 2 matters dismissed. I think Mr. Green, I just spoke to him. He wanted to accept that offer if the officers are present.
Where did you get that offer? Where was that?
From Ms. Schneider.
You've already spoken with her?
By email, yes.
All right, you want to take the deal, sir?
Yes.
All right. I'm gonna put you in a breakout room with your client. His advice of rights, please make sure he understands those advice of rights. All right.
Thank you, Your Honor.
All right, let's go back on the record with Darian Jalen Green. Mr. Green, I've given you an opportunity to speak with your counsel. Do you read him as advice of rights, counsel?
I have, yes, Your Honor.
All right. Can you raise your right hand, please, sir? Where is he? All
Right here.
Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, sir.
You can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or 90 days in jail and or $500 in fine?
Yes, I do.
You understand that you have an absolute right to a trial?
Yes.
Your counsel went over your other advice or rights in the breakout room, did he not?
He did.
You understood those rights?
Yes. Yes, Your Honor.
Questions about those rights?
No, sir.
You know, by taking this deal, you're gonna give those rights up?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No, sir.
All right, let me draw your attention back to May the 21st, 2023, at around 10:18 p.m. in the city of Detroit, in the area of sir. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Yes, sir.
All right. What were you doing out there?
I was walking around Greek Town with my cousin.
No, you weren't just walking around Greektown with your cousin. You had to be, you may have been doing that, but what more were you doing?
Oh, to lead up to the encounter.
Yes.
We walked past the metal detector. Well, we walked around it. It was a group of people. We ended up walking around it because it was so many people. And then the officer came and approached me, asked me if I had a CPL. He looked at me, seen I didn't have anything. He walked away. My cousin, he said something to him that upset him. They got into like a little argument, ended up slamming my cousin against the wall. Then the officer that approached me, the officer that's supposed to be here, he was telling me to back up. I backed up. I don't know if I didn't back up far enough.
Hold on one second. Officer, you have to help me with your last name.
It's Officer Kucharabi. Good morning.
Kucharabi. Good morning to you, sir. Can you put your appearance on the record, please?
Officer Kucharabi, badge to 766.
All right. I have Mr. Green here. Okay, Mr. Green. Now let's get to it. You indicated that the officer asked you to go into the metal detector and you were going around the metal detector. Is that correct? Because you didn't want to wait, right?
Well, they didn't ask us to go through it. It's just like you're just walking past. So like if you walk through it, or some people walk around it.
You didn't want to wait, right?
Technically, yes.
Okay. And you indicated that you had your cousin had some words with the officer, and the officer subsequently detained your cousin momentarily,
Yes.
or whatever, correct?
Correct.
And then what did you do?
I don't know if I think I was just standing too close to the scene. The officer asked me to back up.
Okay, and then what did you do after that?
I backed up and then I pulled my phone out because I tried to record it. Then he grabbed me and said I was being disorderly.
Okay, Officer Kucharabi, did I get that right?
Yes, sir.
All right, is this, you heard basically what Mr. Green says? Is this an accurate representation of what let's hear your
it's not.
version of it is?
It's nowhere close to
Governor,
what.
if I could interrupt, sorry, Officer. Alexa Schneider for the people, P80322. Can I ask, why is the officer making an offer of proof? Is this a trial?
No, it's not a trial, but it's a plea, and counselor indicated that you worked out the plea as charged to this 3-month delayed sentence, and we'll dismiss the other 2 matters. And I want to hear what makes Mr. Green disorderly. And so far, I don't hear Mr. Green, from Mr. Green's representation of what happened, I don't hear him admitting to being disorderly.
Given that,
Now,
Your Honor, if he's unable to make a factual basis, I would ask that the offer be withdrawn. Since he has placed facts on the record, I believe that we need to put it in front of a different judge and have the trial.
all right, counselor.
Ask me.
Mr. Green, were you being disorderly on that day with that officer? that caused the disturbance of the peace and good order of the neighborhood?
According to the officer, yes.
What about you?
No. No, it's not. So it's not gonna be, it doesn't work like that. If you know, what you're doing is you're not saying that you were disorderly. So I cannot take the I cannot take the plea. So, Ms. Snyder, point to me a court rule that says that I cannot, can I hear this trial?
You can give me a moment to look it up, Your Honor, but I would ask Your Honor to recuse himself. You've already asked the defendant about facts on the matter that you've heard off the record, non-sworn testimony. You've asked the officer non-sworn testimony, facts on the record. I believe it'd be inappropriate to have a trial at this time.
All right, point to me the court rule, please.
I need all these on sign.
All right, I'll pass the matter. I'll pass the matter, but so far, you know, either Mr. Green says either Mr. Green doesn't want to admit to what's going on, or he doesn't feel that he was being disorderly, Counselor.
You know, I spoke to Mr. Green, and he wanted to accept this offer. Is that correct, Mr. Green?
Yes, it was.
Okay, and then
I know, let me say this, Counselor, I understand that, and we tried to get an accurate factual basis on the record, but it doesn't sound like to me that Mr. Green feels as he was disorderly. And even when you vardiered him, he indicated that it was that he was being disorderly according to the officer.
I don't know if Mr. Green heard me the first time. I mean, I asked him if it was not just according to the officer, but if it was according to Mr. Green that he was acting in a disorderly manner at that time.
Well, that's a follow-up question to what you've already asked him. And that is a follow-up to what I have asked him. And he still hasn't indicated that he feels that he was disorderly. So I'm not gonna take the plea. And that's because of your clients, to protect your client's rights. If he doesn't feel he's disorderly, then he doesn't. Obviously, the officer felt he was disorderly because he wrote the ticket. So let's pass the matter, and I just want to get a court rule, Madam Snyder, as it relates to your motion, all right? All right.
I'm ready on Green, Your Honor.
Okay. All right, let's go back on the record with Mr. Green. Mr. Green, all right, Ms. Snyder. Let's see, do you have a court rule for me, please?
Yes, Your Honor. I think it'll be best to start out with some case law that explains. So there's one thing, this is from the judicial bench book on disqualification. Reassignment for resentencing or trial is appropriate to preserve the interests of justice and fairness, where it would be unreasonable to expect the trial judge to be able to put out of his or her mind previously expressed views and findings without substantial difficulty. That's People v. Weatherington, a Michigan Court of Appeals case from 1990. The court rule, Your Honor, is 2.003. I believe that this court is in violation of A, B, and C. I believe that there is the appearance of impropriety that Your Honor has made statements to the validity of the client's statements, to the officer's statements. I believe that Your Honor now has personal knowledge that you have asked both the officer and the defendant for their statements about what happened at that time. And I believe that making those statements about the defendant's reliability, about what his facts of the statements are, I believe that's in violation of the Code of Judicial Conduct Rule 2.10, which prohibits statements about pending cases.
Oh, no, that's a lot. Let me try to unwrap this. 2.003, disqualification of a judge. You say I'm in violation of A, B, and C, right?
Yes, Your Honor.
All right, let's see. A.
Are you still there?
Stand by, sir.
Mr. Peterson is here.
Sir, stand by.
Just mute him. Yeah. Please, Ms. Williams Law.
Your Honor, while you go over that, do you want to go off the record?
No, not necessarily. Unless you need to.
No, Your Honor.
All right, as it relates to, we're back on the record, as it relates to Rule 2.003, I read the rule and the substance of the rules come in paren C. A is the applicability. This rule applies to all judges, including justices of the Michigan Supreme Court, unless a specific provision is stated to apply only to judges of a certain court. The word judge includes a justice of the Supreme Court. That would make me have to adhere to the disqualification, and it would include me. Who may raise, a party may raise the issue of a judge's disqualification by motion, or the judge may raise it. So we have that. Ms. Snyder has raised the motion of disqualification. The substance of it in C, which the court finds to be basically the rules of the court that lay out the disqualification. I don't see where this applies to anything that we've done so far. One, disqualification of a judge is warranted, and these are for reasons that include, but are not limited to the following. A, the judge is biased or prejudiced for or against a party or attorney. I don't, if that's the one you're pointing to, I haven't, to my knowledge, showed any bias toward any of the parties. I merely just was taking the plea, and Mr. Green was articulating what he did so that we can make an accurate record of what he did, and he could not, based on his statements, admit to what the officer said. Now, the officer did not get a chance to speak about it, but whether the officer did or not, I don't show that shows I'm biased in any way or prejudiced for or against a party or an attorney. B, the judge, based on objective and reasonable perception, has either one, a serious risk of actual bias impacting the due process rights of a party, as enunciated in Caperton versus Massey, 556 U.S. 868. I haven't read that. Or two, has failed to adhere to the appearance of impropriety standard set forth in Canon 2 of the Michigan Code of Judicial Conduct. That's the appearance of impropriety. The court hasn't, the court only said that I can't take the plea based on the statements made by Mr. Green, and trying to figure out if Mr. Green was, because Mr. Green has to articulate to the court what he did in order for the court to accept the plea. Read on, C, the judge has personal knowledge of disputed evidentiary facts concerning the proceeding. My only knowledge comes from what Mr. Green has told me. I wasn't there. I don't know what transpired. And today is the date and time of sentencing. We have the officer here. And again, I tried to give Mr. Green an opportunity to express what he has done in order to take an accurate plea. And I gave his attorney an opportunity to voir dire his client and to take an accurate plea. And again, Mr. Green has stated that according to the officer, he was being disorderly. which would not constitute something that would be acceptable by the court in the plea of disorderly conduct, because the officer wrote him a ticket. It's kind of obvious that the officer felt he was disorderly. It's not what the officer felt, it's what Mr. Green actually did. So the judge has, the D is the judge has been consulted or employed as an attorney, have not. E, the judge was a partner of the party, attorney for the party, or a member of the law firm representing the party within the last preceding 2 years, have not. The judge knows that he or she individually or as a fiduciary or the judge's spouse, parent or child, this is F, wherever residing, or any other member of the judge's family residing in the judge's household has more than a de minimis economic interest in the subject matter in the controversy that could be substantially impacted by the proceeding. That has not. The judge or the judge's spouse or person within the third degree relationship to either of them or the spouse of such a person is a party to the proceeding, or, and this is paren 1, this is G, paren 1, is a party to the proceeding, or an officer, director, or trustee. No. Is acting as a lawyer in the proceeding. No, the court doesn't feel that way. Is known by the judge to have a more than de minimis interest that could be substantially affected by the proceeding. No. Is the judge's knowledge likely to be a material witness in the proceeding? No. So I have to read the court rule for people. Can you state, state the case law that you cited, Ms. Schneider, please?
People v. Wetherington. It's 180, Wetherington, like weather, INGTON, weather like a snow.
Wetherington.
Yep, 183 Mish app, 360. And it's 1990.
Yeah, 360. 1990. So I have WEATHERINGTON, right?
Oh, sorry, it's Wethington. Actually, I was reading the wrong one. It's so WEATHINGTON, Wethington.
WEATHINGTON.
Yes.
All right. Let me take a moment. Just stand by, counselor, and let me take a moment on that. And then what I'm going to do is I'm going to put you back in the breakout room with your client. All right. And I'm going to give you an opportunity to speak with him and give you an opportunity to update him on what is going on. All right. So you both return back to the breakout room, and I will look up that case law. All right.
As a preview, Your Honor, just to make things easier, I'm sure you know, Mr. Cheeto, but per the court rule, it's 2.0033AI. If judge denies this motion, it has to go in front of the chief judge de novo.
Oh. All right. I mean, and this is something that that needs to be raised. I don't.
He just might want to explain that part to his client at the same time.
So far, I don't see anything in that court rule that I interpret that applies to this. What is the exact rule that you're citing in
2.0033AI. If the challenge judge denies the motion.
No, I'm not talking about that. That would be the outcome of if I denied your motion. I'm talking about the exact on the grounds. On what grounds did you cite? You said grounds 1, 2, and 3, correct?
2.003C1A B, and C. I believe most relevant, Your Honor, is B. As Your Honor knows, the court rule states it's the appearance of impropriety. It doesn't actually matter what's in Your Honor's heart, what's in my heart, what's in the defendant's heart. It's about the appearance of impropriety, which I believe we've more than met that burden.
And explain to me how that you feel the appearance of impropriety has been met.
Because Your Honor has continuously stated, even during this discussion, you're stating that you don't believe he's guilty of disorderly conduct. You've already formed an opinion, which is understandable and fine. We're all lawyers. That happens. We can't unring the bell, but that's why we have these recusal motions. That's why judges aren't supposed to hear facts before they're placed on the record during a trial.
Okay. And what I say to that is, I did not say he wasn't guilty of disorderly conduct. I said what he has said has not met the standard for disorderly conduct, meaning that he hasn't articulated yet that he was actually admitting to being disorderly. And I pointed specifically when counsel wadired him, he says, you did something to be disorderly and disturb the good nature of the community out there. And I'm paraphrasing, so I'm trying to best recall exactly the wording, but Mr. Green answered according to, yes, he said, yes, according to the officer. So those are just the statements that I'm just going by the statements that Mr. Green made, because Mr. Green has to articulate what made him disorderly if he wants to take the deal, and the court just has not felt that he has made that. So I'm not saying that Mr. Green has not been disorderly. I'm not saying that at all. I'm saying he hasn't articulated to the court in a fashion that I can accept the plea. All right, so that's what the court's position. But I do want Mr. Green to go back into the breakout room with his attorney, and I want them to have another conversation. And sometimes you have the situation where the defendant he feels that he's not, he feels that he hasn't been disorderly and just does not, is not going to admit that. Or you have this situation where the defendant just doesn't want to admit it and he has been disorderly. So I don't know what this situation is. So Mr. Give me the correct pronunciation again.
Shaito.
Mr. Shaito, go back in the breakout room with Mr. Green, and then we will move on. And I want you to have another conversation with him, all right?
Thank you, Your Honor.
All right, very well. All right, let's pass that matter. Let's move on. Snyder back.
Not yet, Your Honor.
Why don't you email Ms. Snyder, tell her we need her when she get in here. All right, DeAndre Green, are you there?
She's joining the room.
Oh, is she? All right. All right, Ms. Snyder.
Yes, Your Honor.
All right, let's go back on the record with Mr. Green. Ms. Snyder, Mr. Green, after speaking with his lawyer has quadiered him. Let's do that again with Ms. Snyder present to make sure the parties are satisfied with the plea. Go ahead again, Mr.
Shaito. Ali Shaito, 77614 on behalf of Mr. Green. Mr. Green, I'm going to direct your attention back to May 21st, 2023. Were you present? Were you at the location of in downtown Detroit, Abubian Street?
Yes.
Did you have contact with police that day?
Yes.
Were the officers conducting an investigation of your cousin?
Yes.
Did the officer ask you to step back from the scene?
Yes.
Did you fail to step back far enough so that you caused a disturbance or improper diversion of the officers investigating the scene, therefore
Yes.
disturbing the peace and good order of the neighborhood?
Yes.
I'm satisfied, Your Honor.
All right, Ms. Snyder, are you satisfied?
I'm satisfied as well, Your Honor.
All right, very well. Court is satisfied. I'm gonna find the client guilty as charged with disorderly conduct. Now, Mr. Green, I think that you know, you gotta step back. I know it's your cousin and you wanna, but when the officer's doing his job, you may not like it.
Yes, sir.
But you can't step in between that. You know, if you feel that you've been wrong or your cousin's been wrong, there's other ways to go about doing that. But you don't do anything but cause yourself trouble. So I'm gonna do this one time dismissal upon payment. Dismiss, stipulate the probable cause for the dismissal of the other matters. Counselor?
Nothing further, Your Honor. Besides Mr. Green, you know, he finished high school. He's working 6 to 6 at Advanced Assembly, and I think he's very thankful for the opportunity for the settlement offer and the opportunity to have this matter dismissed upon payment.
Okay, all right, what about stipulating the probable cause? Dismissal of the other matter. All right, so I'm gonna, Mr. Green, 240, when can you pay it?
Does it need to be electronic or cash? Because I can pay
It needs to be quickly, so we can get this matter put behind you. When can you pay?
Okay, I can pay Thursday if it has to be online. If it don't have to be online, I can pay sooner.
And you can pay at the DIV at any time. I'm gonna have you back, let's have you back October the 6th. If it's paid, if it's paid, you don't have to come back. Come back October the 6th at 8:35. Pay it at any DIV that kiosk in the city of Detroit. I'm told you can upload that DIV that app to your phone, or come on down to the courthouse and pay it. Those are the 2 best ways I can tell you to pay it. They'll go through immediately. If you don't have any further questions, sir, continue working, and you gotta let the officer do his job, and it doesn't matter whether you feel you've been wronged or not. If you feel you've been wronged, there's other ways to settle that. Just don't get involved in that.
Yes, sir.
Yeah. All right.
My only question, you said a kiosk?
I'll explain that to you, Mr. Green. I'll show you how to make payment electronically. You said the fine was $240, Your Honor?
Yes.
Thank you. Thank you, Mr. Schneider. Thank you, Your Honor. You have a good day.
Thank you, counsel. Y'all have a very good day. Best of luck to you too, Mr. Green, and officer. Thank you. Have a very good day, and you be safe out there. All right.
Thanks, you too.
Thank you. Enjoy your day.